is on you, and that's why these haters is at you. So just keep on doing you, baby. You don't have to give these fools an explanation. I admit it, I admit it.
I'm here to support Officer Rkelly because I believe he's innocent.
What have you seen in the trial so far? Do you think it's a fair trial?
Yes, I believe it's a fair trial, and I believe now y'all can really hear the truth. It's not a one-sided story no more. He's been defamed in the media, and every media is biased. So now y'all get the truth.
Do you believe some of the witnesses, Javonda Pace, the stories that she told?
No, they're too inconsistent.
And police games at the same time.
Hey everybody, I don't know what's going on with StreamYard. They sent out a message that they're having Hey everybody, I don't know what's going on with problems. So I'm gonna stay on until I guess it start acting up. I don't know. They having problems with uploading brands. What else is saying? Issues with branding features, video and audio. We are currently investigating an issue with our video clips and background music features. Please stand by while we mitigate this. We appreciate your patience. So like I said, I'll try to do my commentary, but if it acts up again, it's not my fault. This is crazy.
In 10 years and has never seen one like this. Okay. And Your Honor, also, I'll state this in my place. The head of our unit stated that the data that is missing would have to have been extracted from the file itself and given to us. It would have had to have been deliberately taken away, those items that I mentioned. So those items were provided to Mr. Williams in pursuant to a request to the Securus for Fayette County. And so we are asking that they give to us what they were given.
I'll let any other things I need to consider.
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play though?
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings, with some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville?
Sir.
You allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize.
Finally, on point 6, Steele says, on Friday, June 7, 2024, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations.
Down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak in 10 years and has never seen one like this.
To be able to play, though?
To be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings, with some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the condition, in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They had everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize.
Finally, on point 6, Steele says, on Friday, June 7, 2024, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland, and I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon.
So as you can see, Steele is pointing the finger directly at Lawyer Love.
You decided to reconsider. You want to hear the video yourself. You had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches. I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro.
As we continue to review the motion for a fair trial submitted by Young Thug's lawyer, Brian Steele, we see a pattern developing, and it appears that Steele is pointing directly to District Attorney Adrian Love as one of the primary impediments to a fair trial. We continue with number 4. We read, over Mr. Williams's objection, when the state was attempting to introduce the January 26, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, lawyer Love told the court that only Mr. Williams's voice could be heard on this video audio, except for one other voice saying words like "yeah" in the background. Undersigned counsel told the court that lawyer Love was incorrect and that several persons' voices were audible on the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting the facts to the court. Of course, lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that lawyer Love falsely accused another member of the bar of misconduct or lying to the court did nothing to admonish lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors lawyer Love and the state of Georgia in this case.
Miss Sergeant Gaither, during the time that the gang unit became involved in the back and forth between If Gang and YSL, did you and your partner have an opportunity to look at the social media page for Demekion Garlington?
Yes.
Madam, can you speak up to
Yes.
Thank you.
And around January 26th of 20, video depicted in State's Exhibit 112 Bravo Bravo have sound to it?
It does.
And does it have more than one voice?
Yes.
Do you recognize the voices?
Mr. Williams and I don't want to speculate on the second person, but I do.
Your Honor, State Tender State's Exhibit 112 Bravo Bravo as evidence.
Any objection to states 112 Bravo Bravo?
Yes, sir.
Basis.
Foundation is your repost.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video. You made a ruling. We moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, right? And Madam Prosecutor said to you, and was not accurate, and I'm going to be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mr. Steele is not accurate. What Mr. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you wanted to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches, I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful.
In point 5, Steele notes that on Thursday, June 6, 2024, as well as Friday, June 7, 2024, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. This was another knowing, malicious, false allegation by Lawyer Love. The court remained mute and failed to admonish Lawyer Love.
All right. Any minister inquiry of me, counsels?
Period, Your Honor. The state received from Defendant Williams a Dropbox link containing purported calls from the Fayette County Jail.
This district attorney, Love, also is the reason why Judge Glanville got recused. This lady has lied on Attorney Steele so many times. Even called him a liar in the courtroom, but got mad when he said that she wasn't telling the truth. Then the judge never corrects her. And that's another thing that Attorney Steele put in his motions, that Hilton, should also be dropped from the trial. Because they all come from underneath Fannie Willis. Judge Glanville, Hilton, Love, the other 3 gentlemen in the prosecutor team. And now it's going around on Twitter that people were saying that they seen Judge Glanville giving the prosecution signal signs during the trial. I never paid attention to it, but the internet is undefeated. And if it wasn't for this trial going public, like I said earlier, a lot of this stuff we wouldn't have seen. And she has got away with so much during this trial. And the judge has to go back and look and see how he favored the prosecution. Now, I know they have the burden of proof. I get it. But even like Adam said, when you make your rulings and we have to deal with it, we move on. Not her. Not her. She argues back with the judge. the judge will make a ruling. Okay, Your Honor, I know you made your ruling, but, and she will keep going on until he changes his mind. And it's sickening because everybody is watching it. And what it makes me notice is how women get away with things over men. Even in politics, even in the justice system, you still have women who use because they are women, to get over. And it's sickening. So wait a minute, let me play this one. I think this is the one.
Excuse me, can I get this? ไม่ได้
That what you were referring to is at the hospital, that the police were telling us to lie, put thug in it when you talked to Detective Lewis.
Okay, but that's.
So when he says, do you remember a thing that there's no evidence took place, he is asserting that, one, it took place, and then asking the witness improperly in front of the jury.
Did he ever talk to Detective Lewis?
No, that's just what I'm telling you, Your Honor. And then Mr. Steele gets here and says to you all this stuff and still never shows.
But just like she lied and said the guy didn't go to the hospital. And that's what Steele put in his motion. And she told the judge that Steele was lying. And then she comes back, oh, Your Honor, he did go to the hospital. She didn't apologize. And what Steele was saying about he believed that, what's his name, Beans, had a conversation with a detective because he spoke about it. When he said, oh yeah, I had lied, to the previous detective. And still feels like he had a conversation with the detectives at the hospital. But the audio is nowhere to be found. The detectives didn't have the recording. She's saying it never happened, but still was saying, why would this man bring up a conversation with a detective if it never happened? And the judge is arguing with Steele, oh, it's not there. You can't bring that up in front of the jury. She's telling the judge, oh, Steele is crazy. He's just bringing up these things, and this stuff doesn't exist. But what about all the things that she stated and lied? She told the judge that the live of Thug and another person from Detective, what's her name, David, whatever, that all they said on there was yeah, and that's it. Like Adam said, they said way more than yeah. And when the judge made his ruling, she even told the judge, oh yeah, Your Honor, if you want to listen to it, all they said on there was, yeah. That was far from what they said on there. So if this is your evidence that you're presenting, you didn't listen to it previously, and then you brought this up in the midst of the trial to present, and you didn't listen to this, and the judge didn't correct her on this.
You anything to suggest that Adrian Bean talked to Detective Lewis?
Mr. Steele, you want to respond to that? Because that's critical to me. I mean, it's critical in the sense that if there was no That would assume facts, not evidence. Hold on. I'm asking Mr. Still a question now. Just hold on, Miss Love. Okay. On the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, it was not shown on the screen. Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says. Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to the detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think the question assumes is that he did anything that would indicate that's the truth. Yeah, well, that you have a good faith basis to ask that. I haven't heard anything of who he spoke with. That's my point. That's the point. But you all can't. But you do, neither one of you can proffer that. Judge, it's not proper, Mr. Steele. No. It's not. It would be a violation before me for you to put that in front of this jury. You're not letting me finish. In the September 17, 2000, you were saying to the court that you have a belief that there is another statement out there. There's not.
I just want to say
because
that.
it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so. Not true. Well, go ahead and make a statement and see what happens. Your Honor, go ahead and make the statement in contravention to what I just told you, and I'm telling you that you will have some problems in front of me. I'm trying to articulate to you. You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. It's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question. Honor, listen. There is a recording between Detective Quinn and Adrian B. where Adrian B. says, I lied to your... But we don't know what he lied about. He says he lied about who he's talking about the car. But we still don't know whether or not he had a conversation with Detective Lewis. And I made it clear, it's 10 years ago. But you said you had, in your conversation with Detective Lewis, that's what you proffer. I said, or any other detective or law enforcement, read the transcript. I made it clear. I don't know. He doesn't remember names. He says it was Detective Quinn. Also on the recording, on Sunday, January 22, 2023, Mr. Bean is the one who said it happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement. We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. Or I have a lot of different remedies I can execute at that point in time. There has to be. That's why. But you can't intimate or otherwise cross over the line when you don't have the statement to back it up. Judge, I've been robbed of the statement. But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up, says, hey, happen to have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again. I'm saying it's been deleted. It's been destroyed. We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now, you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't. Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian B. are on recording where Adrian B. tells Detective Quinn, I lied. About what?
I lied. About what? Who was driving the car? He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for. But that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that their statement exists, there's going to be a lot of unhappy people. Well, what if you don't find out it exists? I still am entitled to it. That's my whole point. Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems. I understand, but you're asking. Well, you have to find a statement for. I'm telling you, the statement was made. It doesn't work that way, Mr. Steele. I'm sorry. No, it does not. No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct. I'm not doing anything. I'm telling you right now. I don't know what you're telling me. I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that. I can ask any question. You are listening to the district attorney level.
This is crazy.
I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me, on recording, that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over. Then we'll have some problems. Then we'll have some issues. I have some issues now. I've been begging for it. The state's supposed to give this. Let me ask y'all. Hold on, Monsieur. Okay, stop for a second. Ms. Love, have you inquired of Detective Quinn where this other statement may be?
Judge, that's just it. Mr. Steele is literally manufacturing evidence. There is no other statement. I have asked whether or not there was a statement. I asked Tracy Lewis at the hospital. Let me be real clear, because he keeps conflating stuff. Adrian Bean never told Detective Quinn that he made a statement at the hospital. I have his transcript.
Okay, but we don't know where he made the statement, and also he's lied. So we don't know what he lied about either.
Your Honor, to be very clear, there's no statement. I have asked Detective Lewis. They can ask Detective Lewis. She never talked to him. Detective Quinn, who is the only person, it's not just police, the only person Adrian Bean asserts to Brian Steele in this recording that he gave us, this 10-minute recording, he said, I spoke to Detective Quinn. It's obvious that he didn't speak to Detective Quinn at the hospital, because the first time he met Detective Quinn was September 17th when he pulls him in for the interview. Literally, Mr. Steele is manufacturing something. So when the court is even asking me, okay, do you know where this statement is? Assuming that there's not a statement. There is no statement. There's no evidence. That's the problem with Mr. Steele asking questions the way that he asked them. He is assuming facts that are not in evidence. And he is usurping the jury's province and their ability to discern and weigh evidence, because he is injecting assertions into his questions about things that don't exist. Similarly, he says, do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013? That's what he asked the witness. You heard the interview. He didn't say that anywhere in that interview. This is the kind of manufactured evidence Mr. Steele keeps putting in front of the jury. He never said that during the interview, yet that's the question. That's the question Mr. Steele asked Adrian Bean on the stand. Nothing like that ever happened. And his conversation during his cross-examination of Adrian Bean, the cross-examination is replete with examples just like that. There is no statement. He can't sit there and say there has to be a statement and then ask the question as if there is one, because that's improperly asserting to the jury something that isn't factual. There's no evidence of it. So to answer the court's question, of course we have asked who spoke to whom. Did Tracy Lewis, did you speak to Adrian B? Tracy Lewis, I talked to Walter Murphy, and I put it in my report. I made a report of that. Calhoun, did you talk to Adrian B? I talked to Frederick Prothro. Here's my recording of that.
Well, somebody talked to him.
And then this idea of destruction of evidence, that is the fallacy that is getting thrown around. That's the problem with asserting facts, not in evidence. That's the problem with them being allowed to ask those kind of questions. Do you destroy evidence? Nobody has said anyone destroyed any evidence. Eduardo Navarro Flores said he heard that Detective Quinn had erased the interview. Well, then why all throughout Detective Quinn's report does he refer to the lie that Eduardo told in the first place? How is that destroying evidence? But they're trying to create a narrative for the jury of things that don't exist. A narrative that somehow the state destroys evidence. There's been no evidence, no suggestion that the state has destroyed any evidence, but they're going to ask you a million times. So that's what Mr. Steele is doing with this whole statement at the hospital. He's going to ask it a million times. So the jury's sitting there going, well, where is it? And then in the end, only person, Adrian B., tells Mr. Steele, at least in the portion of the recorded interview he gave me, I don't know what else he told. I don't know what Mr. Steele told Adrian B. But it's obvious that he's leading him through the interview that the court heard.
He's leading him.